This is a student brief of an international law case presented by Catherine Passaretti of St. Petersburg College for Class ATE 3515, Legal Ethical Issues in Veterinary Technology. The case is known as R versus Menard, which is a Canadian case that was tried at the Quebec Court of Appeal and heard May 18, 1978, with the judgment being delivered July 11, 1978. Mr. Menard was accused of willfully and illegally causing unnecessary pain to animals and was declared guilty by the judge of the Court of Sessions of the Peace. The defendant appealed this decision from the verdict of guilty to the Superior Court, and the Superior Court acquitted the accused. The Crown is now appealing, seeking to reinstate the original decision of guilty. Mr. Menard runs a business that takes care of animals found dead in public places and captures strays which are euthanized if not claimed by an owner within 3 days. He uses a method of forced ingestion of carbon monoxide to euthanize the animals. The animals are put into a small chamber and attached to a combustion engine and gassed to death. The evidence states that dogs die within 2 minutes or longer, depending on the size. The loss of consciousness does not take place for at least 30 seconds. The issues brought forth in this case were: did the animals that were euthanized suffer unnecessarily? Was the method that was used to euthanize the animals in fact painful? And could Menard have used a method of euthanasia that was more humane, that does not cause suffering to the animals? The reasons argued by the appellant were that in the previous case, the judge of the Superior Court misinterpreted the concept of pain and suffering that was mentioned in the Criminal Code 4021A. The judge also erred in finding that the pain and suffering had to be substantial in order to convict Mr. Menard. Next, the judge erred by setting aside evidence given by a veterinary doctor that stated that the animals did suffer. And lastly, the judge erred in interpretation of the concept of the necessity of the animals needing to be euthanized as a grounds of defense. In Canada, animal abuse is defined as any person who causes or permits to be caused unnecessary pain and suffering or injury to an animal or a bird. This is reflected in the Criminal Code 4021A. In Canada, the definition of animal abuse is any person who willfully causes or willfully permits to be caused unnecessary pain and suffering to an animal or a bird. This is stated in the Criminal Code 4021A. The expert witness in question was veterinary doctor Paul Marois. He is also a microbiologist, a professor of virology, and over the course of his career has studied many different methods of humane euthanasia. The testimony that Dr. Paul Morose gave was that the method used by Menard would normally have caused pain, suffering, and even burns to the animals. He explained that the heat released by a combustion engine is intense and that it burns mucous membranes and that particles of carbon burn the respiratory tract of the animals. In his opinion, the best method of euthanasia, if one is considering pain, is by injection of an anesthetic. However, at the time, the injection was typically used for only small numbers of animals because it was more expensive than the combustion engine method. However, he informed the court that in Canada and the U.S., there has been a new system of cooling and filtration of the gas by a column of water, which totally eliminates the particles of carbon and which lowers the temperature of the gas to a level that is tolerable enough for the animals to handle. He also added that the system is relatively simple to install and inexpensive. The judgment of the court, after reviewing the evidence, was of their opinion that the method that Menard used could have been improved at a reasonable cost to him. Due to that reason, the pain and suffering that the animals went through was not a necessity. During the euthanasia, the animals did in fact suffer pain for the 30 seconds until they fell unconscious. The original conviction was restored and Menard was found guilty. The reasoning behind the verdict of guilty was due to the interpretation of the criminal code, which states that it is forbidden to cause pain and suffering to an animal when it is not necessary. It does not matter the amount of the pain that is inflicted. It only matters that it is done intentionally and without a good reason. The court found that the heat released of the combustion engine, which was intense enough to burn, would in fact cause suffering to a conscious animal. The court also found that it wasn't necessary because of the alternative method. The evidence also stated that the defendant had been informed of this system and was notified that if he did not change to the new system, that he would be prosecuted. I could find no dissenting opinion for this final case. The final judgment was agreed upon by the judges. The court did reverse the opinion of the Superior Court and restore the conviction of guilty. The defendant was sentenced to a fine of $200, or if he could not make the payment, he would face imprisonment for 30 days. There were two main questions in this case. First, did the respondent intentionally cause pain to the animals? I believe the answer is yes. The defendant knew that the method he was using did cause pain to these animals and that it did burn their mucous membranes and respiratory tract. Secondly, was the pain and suffering that he caused to the animals by euthanizing them necessary? I believe that the pain and suffering was not necessary due to the fact that the defendant knew that there was a better system that was affordable and that he could have used to alleviate the burns, and he chose to not install it. I also believe that the final punishment did not fit the crime. Mr. Menard caused pain and suffering to several hundred animals, and he was only fined $200 or 30 days in prison. The Criminal Code for Animal Abuse was originally written in 1890, and at the time of this case had not been updated. The penalty for animal abuse had not been looked at or updated at the time and was insufficient to protect animals that had been abused or treated cruelly. This is my reference page for the court case and the images I used in the presentation. Thank you for listening. I look forward to your questions.